This case is like a fire. I hate to use that terminology, but it really is. It burns everything and everyone up around it. Those are the words of GBI agent Jason Shadell. 1 hour, 9 minutes into his interview with Bo Dukes on February 21st, 2017. And I cannot agree with him more. Everybody who comes in contact with this case cannot leave unaffected. This case has consumed Miss Grinstead's family. This case has consumed the lives of every suspect and their families throughout the years. This case has consumed the lives of the accused. This case has consumed the community, and it has surely affected each and every one of you. You have heard things and seen things over the last 4 days that are simply tragic. Things that when you have left this courtroom, you have not been able to get out of your head when you return to your families, when you return to your homes in the evening. These are things that I know you have wanted to talk to people about. These are the types of things you would want to talk to a counselor about, but you can't even talk to each other about them yet because of the oath that you took. These are things that will likely be in your memory long after your duty as a juror in this case is over. I imagine the pressure upon you is immense. This is a close-knit community. Opinions run high. The eyes of the state are upon you. And before long, our jobs are done, and it will be up to you to begin your job. Yet despite all of these things, you must remember that you took an oath. You gave your word, you made a sacred bond, that you will judge this case impartially, without favor to either side, that you will judge this case without sympathy, and that you will decide this case solely upon the evidence that has been presented to you over the last 4 days. Now, as I told you at the beginning of this trial concerns one thing and one thing only, and that is the indictment returned in this case in 2017 that charges 4 offenses. The indictment that charges Mr. Dukes with the destruction of Miss Grinstead's body in Ben Hill County will be tried on a different day before a different jury. The indictment that charges Ryan Duke with the murder of Tara Faye Grinstead will be tried in Irwin County before a different jury. These are 2 separate cases that will be tried in 2 different courts before 2 different juries. There is only one issue before you. That is whether or not Bo Dukes is guilty of the 4 offenses set forth in the indictment before you. 2 counts of giving false statements, 1 count of hindering the apprehension of Mr. Ryan Duke, and 1 count of concealing the death of Miss Grinstead. And all 4 of those counts arise from the 14-minute interview conducted by GBI agent Shadell on June 16, 2016 at the Rochelle Police Department. As the judge told you at the start of this trial, a defendant enters it presumed to be innocent, and a defendant remains innocent until and only if the state is able to prove each of the elements of the crimes it alleges beyond a reasonable doubt. That is a doubt for which a reason can be given, arising from the evidence you have heard, the evidence that you haven't heard, the gaps in the evidence, or from conflicts in the evidence, or any combination thereof. And the only way you can return a verdict of guilty is if you are satisfied that the state has proven its case beyond a reasonable doubt. The presumption of innocence means, by default, the verdict is not guilty, and it's only until the state has proven beyond a reasonable doubt each of those allegations that you can return a verdict of guilt. Now, the legal system has been a long and a winding road for Bo Dukes. It has led him to this trial, and before him is a brick wall. That brick wall is reasonable doubt. And you can only convict him if each of those bricks, each of those doubts, are knocked down by the state, and you are satisfied that they have proven to you beyond a reasonable doubt he is guilty of the offenses that have been alleged. Let me explain to you why the state cannot tear that wall down. Counts 1 and 2 in this indictment charge that Mr. Bo Dukes knowingly and willfully covered up Ryan Duke's confession of murder by denying to the GBI that he discussed, Mr. Dukes discussed, Tara Faye Grinstead with John McCullough during that 2016 interview. Count 2 alleges that he knowingly and willfully covered up that he assisted Ryan Duke in destroying Miss Grinstead's body by denying that he discussed burning the body with John McCullough. Now, the state has presented to you 20-some-odd witnesses, over 90 exhibits, but you don't need to look but at a handful in order to find the answers and to find that there is a reasonable doubt as to these two charges. You need to look to John McCullough's 2016 statement and his 2018 statement. Look to Mr. Duke's 2016 statement to the GBI and then his February 21st, 2017 statement to the GBI. What is it that you were told by Mr. McCullough when he came and testified? He was at basic for 4 weeks with Mr. Dukes at Fort Sill. When the Exodus came around, the Christmas break, if you will, he traveled to Ocilla to be with Mr. Dukes and his family. One night, after a night of drinking, after a night of drug use, at 2, maybe 3 in the morning, Mr. McCullough tells you that Mr. Dukes makes statements to him about having burned a body, having made statements about Tara Faye Grinstead. But according to John McCullough, when this is happening, Mr. Dukes is slurring his words. John McCullough describes him as all out of it. In fact, he tells you that Dukes was drunk and wasted the entire time they were on Exodus here in Ocilla. So much so that when Mr. Dukes returns to Fort Sill, he's on the receiving end of an Article 15 because of the level of controlled substances that are in his system. After that night, they never discuss what was said again. John McCullough never told you that after that night, he approached Mr. Dukes when they were back at Fort Sill and said, "Hey, you told me something that really disturbed. What were you talking about that night?" They never discussed that again. After graduating basic, they don't see each other, They don't talk to each other. They have no communication whatsoever until Mr. Duke sees Mr. McCullough on the stand this week. It is nearly a decade after basic training, and when Mr. Dukes goes to the Rochelle Police Department the morning of June 16, 2016, to meet and talk with Agent Shadell, he can't even initially recall John McCullough's name. It's been over a decade. Does that seem unreasonable to you? Draw on your own personal experiences. Do you remember people that you may have spent 4 or 8 weeks with, spend some time with back 10 years ago, over a decade, that you then have had no communications with whatsoever? Do you remember them? Do you remember the conversations you had with them? Does that sound unreasonable, particularly where somebody was drunk and wasted the entire time? That when the conversation occurs, they are out of it and they are slurring. Dukes is then questioned by Agent Shadell during this interview. And ladies and gentlemen, words matter. The words in this indictment matter. The words and questions that are posed matter. And the words and the answers that are given matter. And when you get back to that jury room, you will have Exhibit 30 with you. That is the 14-minute interview between Mr. Dukes and GBI Agent Shadell. And I encourage you to listen to it. You are the triers of fact. You are the ones who decide what is said during that interview. But I submit to you that you are going to hear 12 questions. 12 questions that bear on this indictment. There are other questions. Do you remember your phone number from back then? Were you living in Atlanta? Those don't bear on this. There are 12 questions you're going to hear that bear on this indictment. And I submit to you they are as follows. The first question posed by Agent Shadell during this interview, he says, I recently got a call from John, and he said basically that while he was here on Exodus with you, and he didn't mention anyone else coming, but he said while you were here on Exodus, he said y'all were driving around, y'all were drinking, things that 19-year-olds do, 18, 19-year-old kids do, and while you're riding around, you made some comments about Tara. He said you made some comments that, at the time he just dismissed as just, alcohol talking. But any reason why, and Mr. Duke says, hell no. Agent Shadell, second question, then asked, would there have ever been any conversations like that? And Mr. Duke says, not that I recall. No. The third question posed, Agent Shadell asked, he was pretty animate that, you had made some comments regarding like burning a body. And Mr. Dukes replied, hell no. Fourth question, Agent Shadell asks him directly, so you didn't help anybody, burn her body, get rid of her, any of that good stuff? Mr. Dukes does say no. The fifth question, Agent Shadell states, I am just curious as to why he would say that kind of stuff. And Mr. Duke says, I don't know. Sixth question, Agent Shadell asked, or why would he say you would say that kind of stuff? And Mr. Dukes replies, the only thing I remember from Christmas Exodus was that we went to a bar one night in Tifton. He took my truck, and I didn't see him again for like till the day we left. There's some small talk, and then a seventh question. Okay, Agent Shadell says, no other reasons why he would say anything? And Mr. Dukes says no. The eighth question, Agent Shadell says, but no reason why he would say that at all. Mr. Dukes says no. The ninth question. Agent Shadell asked, I'm just kind of curious as to why he would say that. And Mr. Duke says, me too. The 10th question. Again, Shadell says, I'm curious as to why I'd say that. He seems pretty animate. And Mr. Dukes just says, yeah. The 11th question, Agent Shadell, yeah, like I said, I'm just real curious as to why, it's been a long time. Why now, And Mr. Dukes asked, well, is he still in the Army? And Agent Shadell says, no, not anymore. He basically said that he hadn't seen you since graduation from boot camp. And Mr. Dukes says, yeah. And then the 12th question, the last question, the end of the interview. Agent Shadell says, all right, that's that. Is there anything else you can think of? I mean, any reasoning, like I said, going back, just thinking about it a little bit more. Any reason he would have even been hinting around about something like that? And Mr. Duke says, no. I mean, like I said, I can't remember. I can't remember a lot about it. I can't remember a lot about that time. Now, you have that interview with you. Listen to it. It's 14 minutes long. Listen to the specific questions asked and listen to the answers that are given. Dukes told the GBI that he did not recall having a conversation with John McCullough. He did not tell them he did not have a conversation with John McCullough. He told them he did not recall having a conversation with John McCullough 10 years ago. And considering how incredibly intoxicated he was based on McCullough's own testimony, does that seem unreasonable to you that he may not recall that conversation? Think about the testimony of the state's witness, Wes Connor, Mr. Duke's cousin. He told you in no uncertain terms he remembers a number of times where Mr. Dukes has consumed enough alcohol that he did not remember what was said or what was done the day before. Remember the testimony of Garland Lott, the young man who immediately went to law enforcement after hearing statements in 2005. But remember what Garland Lott told you. He told you, I've consumed alcohol to the point before where I don't remember what happened or what was said the night before. Think about the testimony of Brooke Sheridan earlier today when Mr. Dukes talks to her about what happened all those years ago following the panic attacks, the anxiety, the talk of suicide. When he talks with her, he's moderately intoxicated. He remembers that conversation, just like he remembers a lot of the conversations he had with people throughout the years. One common theme there, he was intoxicated, okay? But there's a difference between just intoxication and being intoxicated to the point that you cannot remember what was said. Now, the state asked Brooke Sheridan, they go, well, Brooke, you talked to a guy by the name of Jeff Whipple. Did you remember that conversation the next day? And she candidly told you, no, I didn't remember that conversation with Mr. Whipple back around January 20th. But when I got to the GBI and I was interviewed on February 7th, which incidentally is less than 20 days later, I was able to remember that conversation contextually. I told him that. She didn't deny it. That's 20 days later. In 2016, we are talking about a decade. A decade after basic, a decade in which he was deployed overseas to a war and came back. And he is to remember that conversation. When you walk through that door, you don't leave your common sense. In fact, that's why we want a jury of our peers. We expect you to bring that with you. Draw on your own life experiences. Have you ever heard of someone drinking alcohol to the point that they cannot remember what they said or what they did for a period of time? Have you ever heard of anyone doing that? Let's jump forward to February of 2017. The 19th of February 2017, Bo Dukes travels to the GBI regional office, and he sits down in a meeting with Paul Bowden, the district attorney from Tifton, one of Mr. Bowden's assistant district attorneys, and Mr. Rigby. And they make clear to him they expect him, if he's going to cooperate, to be honest, to tell his role, to tell the role of Ryan Duke, to give the names of everybody that he has told throughout the years, and to help the forensic people find Miss Grinstead's remains. And what was said to him? What did Mr. Bowden say? If you do that, we're in a position to be able to help you. 2 days later, he sits down with the GBI. You'll have that interview back there with you. Watch it. 2 days later, talking to Agent Shadell, knowing, based on that conversation not 48 hours later, that at this point he has everything to gain and nothing to lose, he begins telling the story. You heard him. He begins telling the names of friends, of family, giving their phone numbers, admitting that he has told them what happened and knows that the GBI will be contacting them. These are friends and family. And then he is asked about John McCullough, and he tells Agent Shadell, I don't remember the conversation I had with him. I would imagine it took place, but I don't remember the conversation. We were probably drinking a lot that night. That's Exhibit 32. The first clip starts at 36 minutes, 45 seconds. Look at that exhibit. Agent Shadell told you, not only did they expect Mr. Dukes to be honest and completely transparent during that February 22nd, 2017 interview, that he believed Dukes was honest during that interview. How do you reconcile that? When he says, I don't recall in 2016, it's the crime of a false statement, yet when he says, I don't remember during his 2017 interview, it's the truth? How do you reconcile that? Now, what has the state actually presented to you to prove that Mr. Dukes remembered that conversation? And when he said, I don't recall, that he was knowingly and intentionally lying, that he really recalled, he knew that happened, but when he said, I don't recall, that was just trying to deflect it. What have they offered you? Out of the 20 witnesses, out of the 90 exhibits, out of nearly 5 hours of recorded interviews, what have they presented to you to show you that he remembers? Nothing. McCullough and Mr. Dukes never talked about that conversation again. If it had happened, that would give him a reason to remember. It would jog his memory. He would remember that conversation happened, but they never discussed it. Now, McCullough tried to suggest to you on the stand that while they were at basic during those 4 weeks before Exodus, that Dukes made comments to him about how hot a fire has to be to burn a body, or that pecan wood burns really hot. But think back on Shadell's testimony, Agent Shadell's testimony. What Agent Shadell told you, he was unequivocal on the stand that when he talked to McCullough in 2016, when he conducted that interview that's recorded in 2018, McCullough relayed to him that whatever comments were made by Dukes were made when they were on Exodus here in Ocilla. There were no statements made back when they were at Basic. At least, McCullough didn't tell that to the GBI on the 2 occasions he talked to them. You think he would tell them that. He told you he'd been calling law enforcement for years. No record of it, but he'd been calling law enforcement for years, wanting to get his story out. Why would he withhold those details? I ask a lot of questions about the differences between McCullough's statements, the earlier one, the later one. And the reason for that is because there are discrepancies, and where there are discrepancies, you should be skeptical. You should look at that carefully. And I would submit to you that John McCullough is at best an unreliable narrator. His testimony, however, does not prove that Mr. Dukes recalled that conversation in 2016 when he talked to the GBI. In fact, McCullough's testimony underscores that he did not remember because of the description given of his level of intoxication when this conversation occurs at 2 or 3 in the morning at some unknown gas station. Now, certainly there are times when you answer a question by saying, I don't know or I don't recall, it is untruthful, okay? You walk in on your child. Potted plant spilled over, there's dirt everywhere, all over the carpet, he's covered in dirt. You say, son, what happened? I don't know. That's not truthful, okay? But what has the state offered you by way of proof? Actual proof to show you beyond a reasonable doubt that Dukes remembered that conversation. What have they offered you? Now, what I suspect Mr. Rigby is going to tell you is that, we know that conversation happened because if Bo Dukes didn't tell John McCullough from Texas about a body having been burned with pecan wood in an orchard, how would John McCullough have known that? But remember, and go back and listen to that interview. Mr. Dukes didn't say he did not have that conversation with John McCullough. What he says is, I don't recall. The same thing he said February 22, 2017. He didn't remember. Piecing it together, maybe it's likely it was the same conversation, one which Agent Shadell told you he was being truthful. Simply put, the state has not given you proof beyond a reasonable doubt that Mr. Dukes lied or gave a false statement concerning his conversation with John McCullough. The wall has not been knocked down, and it is your duty to acquit on those charges. Count 3 charges Mr. Dukes with hindering the apprehension of a felon, hindering the apprehension of Ryan Duke. And the words they chose to frame that are that Mr. Dukes, on June 16, 2016, did unlawfully conceal a confession of murder made to him by Ryan Alexander Duke, evidence of the crime of malice murder, a felony, a crime the accused knew or had reasonable grounds to believe had been committed by Ryan Alexander Duke with the intent to hinder the apprehension and punishment of Duke, contrary to the laws of the state of Georgia. First, I would submit to you that during the interview with Agent Shadell, that question was never asked. And you can't answer a question that's not asked. Go back and listen to that interview. Go back and listen to the 12 questions I pointed out to you. 11 of those all center around John McCullough. Why would he say this? Why would he say that? Why would he say that you said this? At no point did Agent Shadell say, and he did. Agent Shadell asked a direct question. Remember, one of the questions I pointed out to you, Agent Shadell actually asked, well, did you have any involvement in the burning of a body? That's a direct question. But Agent Shadell never asked that question. He never asked Mr. Dukes, well, ignore John McCullough and all that for a second. Pure curiosity. Do you know what happened to Miss Grinstead? Do you know if anyone killed her? Had that question been posed and he answered it dishonestly, all right, maybe that would be hindering, maybe that'd be a false statement. But you can't answer a question that hasn't been posed to you. Words matter. The words in an answer matter, but the words in the question matter. Go back and listen to that interview. Now, I suspect the state's going to tell you, well, you guys heard Agent Shadell when he's up there on the stand. What did he tell you? Whenever he ends an interview, he'll say something to the effect of, well, hey, you got anything else anything else you can think of? Anything else that you want to tell me? And leave it open-ended. We see this. If you listen to the end of the interview on February 22nd, 2017, that's there. He asked that question. He asked that open-ended question. You'll see Mr. Dukes thinks for about 30, 45 seconds and says no. Look at the end of John McCullough's interview. Agent Shadell asks him directly, is there anything else that you can think of? Anything else at all that you want to tell me? But that's not what is asked at the end of the June 16, 2016 interview. The last question asked is about John McCullough. Is there anything else you can think of why he would be saying these things? The question just simply was not asked. Another thing that you must consider when evaluating this third charge is the way the language is framed. The state has framed this so that it is a confession of malice murder that has been concealed. Pay attention to everything that you've seen. Not once has Mr. Dukes said that he knows why Ryan Alexander Duke killed Tara Faye Grinstead. Not once. That question has been posed multiple times. You have heard it on multiple recordings. You have heard the questions asked to people he has talked to about this. Did he tell you why he did it? I don't know. I have asked him. He's not told me. I don't know. He's never given me that information. He can't tell you whether Ryan Alexander Duke acted with malice or not. He doesn't know. Words matter. The words in the indictment matter, and the words chosen were that it was a concealment of a confession of malice murder. And if you've never been told why someone did something, you don't have knowledge of it. The state could have charged it or could have said felony murder. They could have said voluntary manslaughter. They're the ones who framed this indictment. They chose the words malice murder. Mr. Dukes can't tell you why Ryan Alexander Duke killed Tara Faye Grinstead. That is only a question Ryan Alexander Duke can answer. Finally, when evaluating this third count, I want you to keep in mind that this is what is called a specific intent crime. That is, it has to be done with the specific intent to conceal information and prevent the apprehension of Ryan Duke. Ryan Duke. But is that the situation that you have seen in this evidence? The evidence has been presented and has shown you that Ryan Duke killed Tara Faye Grinstead. Mr. Dukes is charged in Ben Hill County with having participated in concealing her death by burning her body. So ask yourself, if Mr. Dukes made a denial, is he doing that out of an altruistic interest? He wants to protect his friend Ryan Duke? Or is he doing that with the specific intent to keep himself from being in trouble, to keep himself from being prosecuted for what is alleged to be his role, what he's charged with in Ben Hill County, which is destroying the body? Self-preservation is a powerful instinct. Draw on your own experiences. Now go back to the interview, February 21, 2017. There is zero hesitation on Mr. Duke's part to help the GBI apprehend Ryan Duke. You heard it yourselves. I'll be glad to text him. I'll be glad to reach out to him. I'll even be glad to wear a wire. Now that didn't happen, but this is how far he was willing to go to help apprehend Ryan Duke. Listen to what his brother said on the stand earlier today. The state asked, did your brother ever tell you whether any of this was done in an effort to protect Ryan Duke? No, he didn't. Now, the state is going to tell you, oh, that specific intent is obvious, because if Duke is apprehended, then you would be apprehended. But consider that 2016 interview. Dukes is being specifically asked about his role, something he can be criminally charged with. Has the state given you proof, much less proof beyond a reasonable doubt, that Bo Dukes acted with a specific intent to protect Ryan Duke? Or put another way, has the state given you proof beyond a reasonable doubt to negate the possibility that any concealment of a confession by Bo Dukes was done with the intent to prevent his own apprehension and his own punishment? They have not. And I submit to you, ladies and gentlemen, the wall still stands, and you must return a verdict of not guilty as to count 3. Count 4 charges Mr. Dukes with concealing the death of another by denying any information regarding death or destruction of the body of Tara Faye Grinstead. We've went through the questions. Out of those 12 questions I pointed out to you, 11 of them deal exclusively with John McCullough. One of them asked directly if Mr. Dukes assisted in burning Tara Faye Grinstead's body, but he was never asked directly if he knew how she died. As we discussed a minute ago, when Shadell ends these interviews, he ends most of them with a very open-ended question. Do you have anything else you want to tell me? Can you think of anything else? But that's not how this June 16th, 2016 interview ends. You have it in the jury room. Listen to it for yourselves. To say that he denied having any information regarding the death of Tara Faye Grinstead is less than accurate based on the specific questions asked and the specific answers given. But he was asked, did you help burn her body? And he answered no. And you know, having seen the February 22nd, 2017 interview, that that's not the case. He came forward, he bared his soul, he wanted to try to get closure for the family, recognizing the damage that had been done throughout the years, not only to them, but to the other people who were accused. How is that not concealment? You cannot conceal what is already known. You heard yourselves as early as 2005, Garland Lott went to Janice Paulk and Andy Paulk. He wrote a signed statement telling exactly what he overheard between Ryan Duke and Bo Dukes, that she had been killed and the body had been burned. That information was in the possession of the GBI by 2008, just 3 years later. 11 years ago, the GBI had that exact information in their possession. Now, former Agent Rothwell got on the stand and he told you, well, this started out, as the state was describing it, this is a missing persons case. And Rothwell says, nah, we coded it as an other, which is kind of a catch-all. One of those situations where, as he said, we hope for the best, but we presume the worst. But he told you candidly, we had the information. We had Ryan Duke's name, we had Bo Duke's name. We had it since 2008. We presumed that the locals had followed up on it. He told you the lead case agent at that time did not follow up on it. Jason Shadell told you, had that case agent even plugged their names into the database of names associated with this case, when he got this information in 2016, he could have run it, he would have seen it was right there. But that didn't happen. Rothwell read to you the portion of Leitner's report from 2008. It's on page 3. Their names are right there. What is told is nearly the exact same thing that has been presented to you by the state 11 years later after they had that information. Rothwell told you he accepted full responsibility, but I don't think it falls on his shoulders. This is a failure organization-wide. It does not fall solely on his shoulders. When Agent Shadell took this case over in 2009, he became the third case agent to have it. This is 4 years after Miss Grinstead went missing. At that time, it is the largest case the GBI has had. It has garnered national media attention. What did he tell you? I did not go back through every report. I did not go back through and look at what the prior agents had done. I mean, I looked back at it some, but I didn't go back through to see if there are things from years ago that we need to look at. And this is 2009. He only needed to look back in the last 12 months. Because remember, it's 2008 when they get this information. I mean, he isn't getting this case in 2017, where you've got a decade's worth of information to go through. I think you guys have heard it. We've talked about the numbers. There's something like 1,990 some odd exhibits and reports in this thing. It's about 3,000 pages or so. I know Mr. Rigby's read it. I've read it. Would it have taken that long in 2009 just to go back through the last 12 months? Because those names were there. The exact answers were there. You can call it the allocation of resources. You can call it presuming other agencies did their job and followed down leads. You can call it whatever you want to, but the answer was in their file. All they had to do is read it and simply put, they dropped the ball. Ladies and gentlemen, you cannot conceal from the state what they already know. Now, Mr. Rigby's going to tell you, he's way off base. This is just a missing persons case. It's just a missing person. Like you heard, this, it could have been the runaway bride. Maybe she went out for a jog and never came back. It wasn't until 2017 that we knew she was no longer alive. And had Bo told us in 2016, well, we would have known then. No, no, no. Law enforcement had this information in 2005. The GBI had it in 2008. And had they just read the files and followed the leads they had, we wouldn't be here today. Ladies and gentlemen, you cannot conceal what is already known to the GBI. The state has not knocked down the wall, and you must return a verdict of acquittal. Now, I promised you at the outset of this trial I would try to be the absolute best steward of your time that I could, that I wouldn't be wasting time on extraneous questions, dragging things out unnecessarily. And I've tried my best to do that while defending Mr. Dukes to the best of my ability. And in a moment, I'm going to sit down, and Mr. Rigby is going to give you the state's closing argument. He gets last word. It's kind of like an argument with a spouse. That's the problem with being a defense lawyer is the other person always gets the last word. But listen to him. Listen to the state's case. Go back through, look at the testimony of their 20 witnesses, look at their 90 exhibits. When you do so, you will see that they have not proven the 4 charges in this indictment beyond a reasonable doubt, and it will be your duty to acquit. You must understand that discharging that duty is not a free pass. Bo Dukes will stand trial in Ocilla for the 3 charges the state has brought against him for the destruction of Tara Faye Grinstead's body. But that is a question for a different jury in a different county in a different trial. Weigh the evidence, give them the chance. And when you do so, you will return a verdict of not guilty. Thank you, ladies and gentlemen.